question, my point of the question is prejudice as used in 97126 the same as the prejudice in the general prejudice statute? You know, there's a general prejudice statute.
I would say prejudice here would be the same as when you have an ineffective assistance of counsel claim, when you're dealing with a not guilty plea and they're not given enough information, that he would have to prove that he would have pleaded differently, that he would have pled guilty instead of going to trial, which, you know, usually a person who is aware that they are facing a much stronger or more serious sentence doesn't tend to want to plead. They want to go to trial. That's why you don't have a lot of people pleading to first-degree homicide.
But the usual prejudice for ineffective assistance of counsel or other substantive issues is there error sufficient to undermine confidence in the verdict or in the judgment? And so here you might say, hey, there was a lot of evidence against him, therefore your confidence is not undermined. Is that?
Well, in a plea case, when you're saying the defendant has to even allege that they would have pled differently but for the ineffectiveness of their counsel, and I would say that's exactly what's going on here, because what his prejudice that he is claiming is that he wasn't able to plea bargain.
Don't we need counsel? I'm going to return to Justice Brasser's middle road.
Mm-hmm.
It seems to me if you would assume that under 970.021 that shall contain the possible penalties for the offenses set forth requires the minimum here of 25 years that's mandatory. If you would assume that and assume there's a violation, what do we do with regard to prejudice? Do we remand it to the circuit court for a determination on prejudice? Here the circuit court said there's prejudice, excuse me, I'm not sure that's the right word, but you said that there's a problem
Of great magnitude.
of great magnitude. Yeah, that's right.
Yeah.
So, but I don't know if he declared that as a matter of law, if that was a finding of fact for which we would say then is it clearly erroneous, or was there no record developed? What would the defendant have done? I'm asking these rhetorical questions, of course. What would the defendant have done had he known? Is that something that should be made a record of, and then the court decide if there's prejudice? What do we do with this prejudice?
Well, what the state would like you to do is find that there was a forfeiture and send it back for an ineffective assistance of counsel.
I know you want that, but
and
you know we're hesitant to do that because forfeiture is just decides this individual case, and we didn't take a case for forfeiture. So give us another alternative.
Well, I think that if it's not going in that direction,
If it were not
and that there would be a pleading requirement on Thompson's part to plead at least sufficient prejudice so it would even get to a hearing stage. And I think what he has pleaded is far too speculative. He never pled that there were any negotiations. Everybody's guessing there probably were, but I don't know that there were. He's certainly not alleging that the prosecutor offered him something that didn't have the mandatory minimum. I think if this court were to find that they're not comfortable with saying that the pleading requirement was too speculative and can't even go forward, that then you could remand it for fact-finding. And I would say at that hearing, you know, the defendant could testify, counsel could testify, and the prosecutor at the time could testify as to what plea negotiations there were and whether anything was offered that didn't have the mandatory minimum.
This is a little unusual, it seems to me, in some of the cases we see. Went to trial, found guilty of one and not guilty of the other.
Right.
So there's something going on here other than what we oftentimes see.
There is, and that's why the state, sort of out of frustration, suggested maybe there's another alternative, which is that you sentence without the mandatory minimum if you find that it was required. That's not a good option for a variety of reasons. One is I'm not sure that it's legal because there is a mandatory minimum. Second, if it would set a really bad precedent for sandbagging, because then you'd really have incentive on the part of the defendants to sit on errors that they know are in the complaint, that are either underreported their maximums, or they didn't include mandatory minimums.
Counsel, talking about setting a bad precedent here, it seems to me the prosecutor, you might disagree on the interpretation of the statute. The prosecutor did not notify the defendant there was a mandatory minimum sentence in the complaint, and he didn't notify him because he didn't understand that there was a mandatory minimum sentence. The judge had a statutory duty to inform the defendant of the penalties at the initial appearance. He failed to do that. Defense counsel didn't understand the mandatory minimum penalties. So what you're talking about is a defendant who went to trial on 2 counts facing mandatory minimum sentences of 50 years when he's thinking he could have gotten probation on those 2 counts. I mean, it's a total failure to inform the defendant, and yet the only person who's supposed to suffer any consequences of all of those failures is the defendant.
But
Is that the precedent you want?
But what consequence did he suffer, really? He got his trial. He got the right to remain silent, the right to testify, the right to a jury. He got his rights. So he gave up no rights. It's very different from a situation where you've got a guilty plea and you have to make a knowing waiver of your trial rights. In that sense, yes, at that point, I do think and that's the Moore case, that the defendant has the right to know before they give up their trial rights. Here, he chose to go to trial. He got all of his rights, and in fact was acquitted on one of the charges and not on the other. And so, the other thing is, if this court remands it back for a new trial, it doesn't put all the parties in the same position. It put, the state can't retry him on the one he was found not guilty on. So, it doesn't seem like a good remedy to retry this person after he's had a fair trial. So I guess that all goes to prejudice. How was he truly prejudiced? The only way he can show any prejudice is that he would have had a way to get out of the mandatory minimum. And the only way he could get out of that mandatory minimum is if the prosecutor would have been willing to offer some kind of plea deal to something that didn't have a mandatory minimum. And there's absolutely no reason to believe that that would be true.
Counselor, doesn't the court, according to our recent jurisprudence, also have to approve a change if the information charged him was sexual assault of a child, which it did here, and then there was some kind of plea negotiations, and so they're gonna, I don't know what in the world they would put up as an alternate, but say it's some other